Namaskar, Dilip Singh, advocate. Welcome back. Hope you are ready for the new journey with me in journey of Constitution of India. In my last three videos, I have given you ideas about various judgments and the basics of Article 14. Now you are watching part 4 of the Article 14 Right to Equality series. We begin this journey with 1977. The political scenario had changed. Janata Party has won the parliament election and formed the government with Prime Minister as Morarji Desai, and country has started a new journey. The judicial attitude had also undergone a sea change after the traumatic experience of emergency. The political atmosphere was charged. Janata government was taking action against the excesses committed by Indira Gandhi and Sanjay Gandhi during emergency. Shah Commission was formed. In that atmosphere, Government of India impounds the passport of Maneka Gandhi, wife of Sanjay Gandhi, and sends a letter to surrender the passport. The letter was sent on 2nd July 1977 by the Regional Passport Office. After receiving that letter, Maneka Gandhi wrote a letter asking for statement of reasons for impounding the passport and why the passport has been impounded. She was told by the Regional Passport Authority that the reason cannot be disclosed to her in the public interest. So, Maneka Gandhi filed a writ petition under Article 32 in Supreme Court of India against the order of Passport Authority. Although this case pertains to Article 21, the right to personal liberty, but in this case particularly, an issue was framed whether Article 14, 19 and 21 are independent or they can be read together. Another issue was the scope of intervention of principle of natural justice in administrative decisions, administrative actions. So the journey of the main issue of the independency of the different articles started in 1950 in A.K. Gopalan versus State of Madras case, where it was held by majority that all the fundamental articles are independent and they cannot be read together. And this view was this ratio of the Gopalan case was affirmed, and that continued, and that was taken in ADM Jabalpur case, where ADM Jabalpur versus SS Shukla case. Now, in Gopalan case, there was a dissent judgment given by Justice Syed Fazal Ali, where he specifically said that all the fundamental rights enshrined in the Constitution do not act as separate codes up to themselves and have to be read together as they overlap. In 2018, I was hearing a lecture of Justice Chandrachud, and he specifically mentioned that there are three important dissenting judgments in the history of Supreme Court of India which shaped the future judgment. And first among them were the dissenting judgment of Justice Syed Fazal Ali. After 28 years, on 25th January 1978, in Maneka Gandhi versus Union of India, AIR 1978, Supreme Court 597, Supreme Court agreed with the dissenting view of the Justice Fazal Ali, and the concept of golden triangle of Article 14, 19 and 21 was given or developed. In Maneka Gandhi case, 9 judges bench were headed by Chief Justice M.H. Beg, M. Hidayatullah Beg, who had superseded Justice H.R. Khanna when Justice Khanna gave the dissenting judgment in ADM Jabalpur, and then Prime Minister and then Congress regime superseded him, and Justice M.H. Beg was made Chief Justice of India. There is one interesting fact also about this bench of 9 judges. Justice Murtaza Fazal Ali was part of this bench, who is son of Justice Sayyid Fazal Ali. So first time we saw that after father's son was elevated to the Supreme Court, and interestingly in this bench he was. So the concept initiated by his father was developed by the son, and in this bench there are three more judges in this bench: Justice P.N. Bhagwati, Justice Chandrachud, and Justice Krishna Iyer. Why I am mentioning these three judges together? Because they were the part of E.P. Royappa case, where the concept of non-arbitrariness in Article 14 developed. In addition to the reasonable classification doctrine. So, it was held that the principle in this Maneka Gandhi case, it was held that the principle of reasonableness of Article 14 must be accompanied with the procedural fairness of Article 21. So this 14 and 21 were read together. This case traveled a journey from procedure established by law as given in the Article 21 to the concept or doctrine of due process of law. Let me share one interesting incident related to due process of law. Sir B.N. Rao was constitutional advisor of the Constituent Assembly, and at the time he was drafting the constitution, he visited several countries and met with the chief justice or judges of those countries. In this process, he went to USA, America, and he met Justice Felix Frankfurter of American Supreme Court. And Justice Felix suggested Sir B.N. Rao that do not include concept of or doctrine of due process of law in your constitution, as it will burden the judiciary. And B.N. Rao understood the message that at the nascent stage, when the democracy was at the nascent stage, this concept will not help a lot. So it was left for the future, even during the discussion of the Constituent Assembly. Why I am mentioning it? That in 1978 in Maneka Gandhi case, the judges of Supreme Court somewhere thought that that maturity has come in the democracy, where this concept of due process of law can be incorporated while interpreting the fundamental law, and more particularly Article 21. So what the intention and what the message was in this judgment at large, that there is the justice is not only be done, but it must appears to be done. So concept of fairness require to be taken care of every stage, whether it is legislation or administrative action. Maneka Gandhi case heralded a new era of constitutional jurisprudence. It recognized the right to, recognized the right to travel as the right to personal liberty. Secondly, the importance of reasonableness and non-arbitrariness with principle of natural justice was emphasized in legislative and administrative action. Third, that section 10 subsection 3 of Indian Passport Act, which was challenged by the petitioner as a case which violates the fundamental right, the court said no, the section 10 subsection 3 is valid, and Secondly, that most importantly, which I said earlier, they recognize the concept, the organic concept towards the fundamental right, the integrated concept, integrated approach to fundamental right. So this was all in the case of Maneka Gandhi. Now the second important case involving right to equality, which I am sharing with you, is Rajbala versus state of Haryana, which was challenged on the ground of Article 14. And here the constitutionality of Haryana Panchayati Raj Amendment Act 2015 was challenged because it has created certain disqualifications for the candidates who were willing to contest election. These five disqualifications were: first, that all those persons who against whom a charge has been framed in court of law for an offence punishable for imprisonment not less than 10 years. Second, all the defaulters of agricultural loan. Third, defaulters of electricity bill. The fourth, which is most important and which was the bone of contention in this case, was the person not having the specified educational qualification of class 10th or class 5th as applicable in the different cases will also be disqualified from contesting election. And fifth was person not having a functional toilet in the residential home. So the basic contention in this case, though, on this ground was the educational qualification, because there was that act prescribed an educational qualification of class 10 and class 5 in different categories. For general, it was class 10. For a scheduled category, it was class 5. Because many persons who are sitting office bearers of the Panchayati Raj system in different panchayats were not eligible to contest the election. So, but this act was challenged basically on the ground of arbitrariness. The case was before a division bench comprising of Justice Chamaleswar and Justice Abhay Manohar Sapre. Justice Chamaleswar was the author of the case, author of the judgment, and he specifically held that it is not permissible for Supreme Court to declare a statute unconstitutional on the ground that it is arbitrary. What he wanted to say that, this judgment says that merely a court or a judge finds a judgment a statute arbitrary cannot be declared invalid, because the legislation is prerogative of legislature and they are better trained, they are better placed to understand the pros and cons and the values of the legislation. So the court cannot sit on the wisdom of legislature while deciding a case simply on the ground of being arbitrary. So court cannot declare a statute invalid on the ground of arbitrariness, because the concept of the presumption of constitutional validity is very strong in favor of legislation. So this was on this ground the act was declared valid and the petition was dismissed. In the next videos of this series, I'll discuss two very important judgment of recent time. In 2017, a judgment of 9 judges bench in Justice K.S. Puttaswamy versus Union of India, and another important judgment of 2017 is Navtej Singh Johar versus Union of India. Besides that, I'll also mention some other judgments for having relevancy with it, and that will be final video of this Right to Equality series. Now let me share something which I get with the interaction of the persons who watch the video. Yesterday I had a call from one of my friend who said that he watched the part 3 video and he found it very useful, but he could understand the whole concept of right to equality after he watched first video, then second video, and then third video. So he asked me to suggest my viewers that they should watch the videos in chronology and in sequence. They will be better benefited. And for further information, you communicate with me, comment on my channel, or rather I'll be giving you my email ID, so that if there is any question from in your mind, you can share with me. Thanks for being with me in this journey of Constitution of India. Please subscribe the channel so that next video can reach you in time. Namaskar.